Welcome, everyone. My name is Terry Swain. I'd like to call this meeting to order. The time is 6:30 Tuesday, March 25th, 2025. This is the Planning Commission meeting, our inaugural one, so thank you for your attendance. In attendance today is Chris Adkins, who's joining us virtually, Joe Bodner, Kristen O'Rear, Matt Alexander, and my name is Terry Swain. The first thing that we need to do is, or our business is approval of the agenda. Commissioners, I will now entertain a motion to approve the meeting agenda for this evening.
Second that motion.
We have a motion. Can I get a second? All those in favor signify by saying aye.
Aye.
Any opposed, say nay. Measure passes 4-1. 4-0. Planning Commissioners' comments. This is our initial meeting. I'm just excited to be a part of the city of Mulberry, excited to serve our community, as I think all of us are. Excited to be during this initial part of our city and our community coming together for the betterment of all. So we're just excited to be that and look forward to serving everyone. Public comments. I will now open the period for public comments. Please reserve your comments related to a specific agenda item when I call for comments on that item. Comments to the Planning Commission should be limited to no more than 3 minutes. Groups wishing to address an issue should select 1 or 2 spokespersons. The time allowed for all issues should not exceed a total of 10 minutes. Issues raised at this time are generally referred to the Secretary for review. Responses will be provided at a later date. Okay. Will you please approach, you have a microphone or the podium and state your name and your address, please. Do we have any public comments? Okay. Looks like we have one.
What they were grabbing. See. And there's no saying what this says old business. I'm not quite sure what the old business entails before I would ask this question.
We have no old business.
Okay, that's what I thought. When you said inaugural, I thought, I don't know what old business there is.
Right.
My name is Nikki Phillips and
Address, Nikki.
I actually live in Hall County.
Okay.
I'm a longtime resident of Gwinnett County, but now I live in Hall County, right on the Gwinnett-Hall line. Half the community is in Hall, half is in Gwinnett. And there is a new development going in right behind us,
okay,
where the properties butt up to one another. And I was trying I've been back and forth with emails, just trying to get some information as to how this is going to progress, because 20 years ago, that development that property was owned by somebody else. And they were going to do a similar type of, multi-home subdivision. And it just fizzled. They got all their zoning done, all their permits, everything. And it never happened. It never happened. But they sent us information saying, hey, FYI, here's what our plans are, kind of phase 1, phase 2, phase 3. Here's our permits. Here's what our plans are for a buffer. Here's how many houses we're putting in, just a general prospectus of what was coming. And then nothing happened. And now here we are, fast forward 20 years, and clearly something's happening because all of the trees have been removed, okay, and the building is soon to start. But we still don't know. Is the game plan the same? Have they changed plans from what the original developer was going to do? Is it similar to that? Our biggest concern, because we're at the bottom of the hill, when you see the topography of this, it sits up high, and our street sits at the very bottom. So from a drainage standpoint, erosion standpoint, we're kind of wondering, what is their erosion control plan? Right. Is there going to be any privacy screen? Because the previous builder had talked about putting in 50 foot of buffer. And I don't know if that was like just the existing trees
Right.
that were already there, because that was a heavily wooded lot. Or if he was going to put in, some Leland cypress street, something vegetated, just to give you some screen. Not sure, but clearly we're not at 50 feet anymore.
Right.
Because those dozers have really came in tight. And so if the plan is still for 50, maybe they're going to plant something.
Right.
There to give us the screen and to help with that soil erosion. So I'm just trying to get information, and I put in an open records request. I did that. And so waiting to, hear back on that. But is there anything that you can share that you know about it? Because I know it originally started with Gwinnett County. They did all the permits and zoning and
Right.
everything last year.
Okay.
And now.
Yeah, I'm not sure that's a question that we have any answers to, because we have specific roles for if somebody's changing a zoning or if
Okay.
somebody's changing.
Did anything change?
We have not had any applications to this point because they've been in a moratorium
Okay.
on those. So Rebecca, I'll
Yeah.
defer to you.
So at this point, it's something that we can talk to you afterwards. Public comment is, you can provide, pose the questions, and then we can follow up with you.
Okay. Okay.
Anything else?
No, I was just coming just to see what was gonna be on the agenda. When I saw old business on there, I thought, well, maybe it'll come up. So, all right, thank you.
Thank you so
Appreciate it.
much, Nick. All right. Anyone else?
Are we free to just, I'm sorry, I've never been to one of these.
Right. Oh, this is a public comment.
Okay.
So you're free to speak.
Sorry, just any topic
Um,
or,
it has to be related to our agenda item today.
okay.
All right. Anybody else? All right. Hearing none, we'll move on to old business. We do not have anything on the old business. So we'll move on to new business. Portion of the agenda. Our first item of the new business is as follows: adoption of the bylaws and meeting guidelines. Commissioners, I will now entertain a motion to adopt the bylaws and meeting guidelines.
And I can also provide a brief kind of overview of what this is. These are the procedures by which you all will be governed. In addition to the Unified Development Ordinance, there's a set of procedures that are based on state law and kind of carried out in the ordinance as far as how to conduct your meetings. But this is more specifically kind of how we can call meetings, who the various officers of the Planning Commission are, how they get either appointed or nominated, and then even down to the structure of the agendas. And so these just outline the basic kind of meeting protocols and procedures that we will follow in conducting meetings. And then as a catch-all, kind of Robert's Rules of Order, where there is no kind of indication within the bylaws and guidelines.
Thank you, Rebecca. I'll now entertain a motion to adopt the bylaws and meeting guidelines.
Second.
No motion?
Motion.
All right, I'll make a motion to adopt the bylaws and the meeting guidelines.
Can I get a second?
Second.
All right, now we open the floor for discussion. Y'all were provided the rules and guidelines in advance of the meeting today. Trust that you had time to look through them. Is there anything for concern or discussion?
Nothing.
Okay. If there are no other questions or discussions, I'll now call for a vote. All those in favor of the motion stated as it stands, please signify by saying aye.
Aye.
Any opposed, say nay. Hearing none, the motion passes 4-0. All right. Next item of new business is as follows. We have the election of a vice chair. Commissioners, I will now ask for a motion to nominate a vice chair. A motion.
I'll make a motion.
Okay, can I get a second?
I'll second.
All right, I now have a motion and a second, so I will open the floor for discussion. I've had previous discussions with Mr. Chris Atkins with regards to this position. And my recommendation would be with Chris, for Chris. He has an expertise in the development field, and I think it would be a fine choice for this matter. And so is there any other further discussion that y'all have? Okay. Mr. Atkins is not here with us today, other than virtually. He said if we all agreed to that he would accept it. So I have a motion and a second. I'm going to call that for a vote. So I recommend Chris Atkins as the vice chair to the Planning Commission. All those in favor say aye.
Aye.
Any opposed? Say nay. Hearing none, the motion passes 4-0. Over too quick. Congratulations, Chris.
Thank you very much.
All right. Motion carries. Okay, this part right here. All right. Well, the next item for business is as follows: the Planning Commission training. I will now turn it over to staff to conduct the Planning Commission training.
First, now we get to the fun part. I get into the nitty gritty. So I think first, perfectly timed, we can kind of introduce all of staff and then move into the training. So I'm Rebecca Kiefer, the Planning and Development Director.
Hi, everyone. I'm Jamie Palmer. I'm the interim city manager.
And then here with me, also.
Sarah McQuaid, I'm a planner. Mackenzie Batista, also a planner.
And so we'll be a portion of your support here for the Planning Commission. And so not only today through the training and the agenda item, but as you have questions and kind of get into this a little bit more, feel free to reach out to us with any questions. And we've also got some other team members, but wanted to introduce you to several of the support teams that you'll have the pleasure of getting to know.
Great.
Thank you.
Looking forward to it.
All right, so diving in, there is a lot having to do with planning and zoning and the Planning Commission procedurally that we want to walk through, kind of help you understand what your duties are, what your authorities are, and then some of the not only ordinance authority, but also just various things to be aware of as you're making certain decisions. So our agenda for the training is here up on the board, and we've provided you copies if you want to take notes or anything. We're going to talk about kind of board structure and authority of each of those boards, kind of who makes what decisions, what the process is for some of the primary. We have both zoning decisions or legislative decisions is what they're called, or quasi-judicial decisions, being variances, and then go through kind of our meeting procedures and other tools that you'll use. And we can kind of quickly go through some case studies, some considerations that you might use with some hypothetical cases. So effectively, we are going to go through that authority, review what you've got to make the decisions, and like I said, the tools, future land use map, development map, and the zoning ordinance, as well as the various tools that staff develops for your use. And thank you guys for serving. So in the Unified Development Ordinance, it defines the Planning Commission and your authority. Everyone serves a one-year term with this first round of appointments, so that everyone doesn't, if there are members cycling off, we didn't want everyone to cycle off all at the same time. So we've added kind of 2 consecutive one-year terms for a couple of members. And we might, over time, we will more than likely amend the ordinance to make it a little bit longer. Once you get kind of your footing, then you could potentially be rolling off. But also stated within the ordinance is until kind of reappointed, even after that year, you would still be able to and be eligible to serve on the Planning Commission. The chair is appointed by the mayor, and the vice chair, of course, you all just went through the process of naming Chris as the vice chair. Quorum is considered a majority of seated members, and that we outlined in the bylaws to define that. And so with having 5 members, that's a minimum of 3. So this is the first of many plugs of when we get into a cycle of about a week before a meeting, sending out the agenda, and even sooner than that, if you know that you're not going to be at meetings, the July meeting, sending that to us so that we can plan, we can notify applicants and potentially schedule new dates before various advertising deadlines and things. So the sooner you can notify us of the absences and kind of RSVP, kind of do a final RSVP when we send out those packets, kind of the smoother we can kind of maintain this process. Tie votes are recorded as no recommendation. So if the 4 of you voted on anything and it was 2-2, then that would move forward as either a failed motion or no recommendation if it's in the case of a case that is going on to city council. And then a decision is required within 30 days. So what that means is you can hear a case, hear the public comment. We'd have to kind of understand that's an ordinance requirement. If you'd like to postpone to the next meeting, we have to understand, is that within 30 days? If not, it does need to move on to the city council meeting with no comment or no recommendation. Feel free to stop me if you guys have questions as we're going through. So you all make recommendations to city council, and you make them on 3 different types of applications or application types. Amendments to the zoning map, and those are rezonings, special use permits, and I'll get into detail about what each of these are, and amendments to the zoning ordinance, so text amendments, which are what's on your agenda tonight. There are no, aside from kind of your own governance, there are no final decisions that you all make as a body. So first, rezonings, again, in the ordinance, it also refers to these as map amendments. And so what these are, changing the zoning designation from one to another. That could also be true for an overlay, applying an overlay, removing somebody from an overlay district. So, and you've got your base zoning district that outlines the various requirements of bulk standards. You know, what are their setbacks? What are their heights? What kind of uses can they go in there? Sometimes there are overlays that are applied on top of that, and they're usually more restrictive with respect to, could be architectural standards, could be use standards, streetscape standards. And so when we apply that to a property, that is another layer of zoning, and we have to do a map amendment to either apply that to a property or remove it from a property. We can change the text of it without a rezoning, but to apply it to a new or change it from an existing property, that requires a rezoning as well. These are legislative decisions. And so those are kind of discretionary decisions where you can use a set of criteria to help guide your decision, but it's basically a policy decision of eventually mayor and city council. But you're using a set of criteria to help you kind of think through the thought process of whether or not, you know, this is a rezoning or what the case may be, special use permit that is appropriate for the city. Again, you as planning commission will review and make a recommendation to city council, and then city council makes the final decision on those rezonings. Public notice. So there are state law allows local and county governments to enact zoning through the police powers. And but what they say at the state level is it doesn't tell you how to zone, it doesn't tell you what to zone, but it does say if you're going to zone, these are the specific procedures that you have to follow. And so one of those such procedures are notice requirements and how early you have to post it, and what and where you post and who you post it. So for a rezoning that is initiated by an applicant, I'm not going to get into what's required at the state level and what's required at the local level. So I'll just articulate what's kind of at the local level, because there are some additional requirements that we have in the local ordinance. So there are letters required when there's a rezoning request that is an applicant initiated request. Letters that go out to property owners. Now in the city, it's 2,500 feet. At the county, it was 1,000 feet. So that was a change with the initial adoption of the UDO that was made, was to kind of expand that buffer. And those are mailed notices buffered around the subject property. There's also a sign posted on the property, and then a notice published in the newspaper. It's going to be published a minimum of 15 days, but not more than 45 days before the public hearing. And the public hearing is held before the official kind of state mandated public hearing is held before the mayor and city council. So those are kind of the dates of those review criteria. On the next slide, I'll show you the review, what you'll use to kind of gauge your assessment of those rezonings. And then appeals, they are appealed de novo, which means when it gets appealed, new record can be created in that appeal. So the case for why that might not be right for the city can be created after the fact and submitted as part of that appeal. And so, that's just kind of important to, the decisions that you make. Conversely, I don't know if I had it in here, because I was just going to notify you just for your information, variances, quasi-judicial decisions are reviewed on the record. So if it's not said at the meeting or presented in paperwork to the Zoning Board of Appeals, then it can't be presented as part of it because they're reviewed on the record. So the rezoning criteria, what we will do for every rezoning case that comes before you is we'll produce a staff report. Now, staff report is going to outline not only will you have the applicant, the application, the site plan, any kind of renderings, that entire packet, but you will also have at the top of all of that a staff report created by staff. You'll probably have kind of a site location map outlining the parcel, just so you have some general context, the address, some kind of basic identifying information about the parcel. Sometimes address is difficult with a green field because it's not been addressed yet. So we might have to put kind of an intersection or something like that, but we'll have the basic identifying information, summary of the parcel, of the case and the request at hand, as well as a rundown of all of this criteria. And so we will make a recommendation after we kind of proceed through this. You can see whether it's going to permit a use suitable in view of the use and development of adjacent and nearby property. You can see that it references the unified plan and the future development map. So that's the comprehensive plan, the kind of guiding policy document that we look to for a lot of these decisions. And then this last one, whether there are existing or changing conditions affecting the use of development that would either support the zoning proposal or the approval or disapproval of the proposal. And so there could be kind of shifting conditions on or near a property that either justify or don't justify some of those decisions. So that's all just to help guide you in making a recommendation. I will tell you what we as staff can kind of opine based on that criteria and based on kind of our expertise. You could very well come up with a different opinion of how a particular project meets that criteria, and that's okay. That gives you a basis if you if you follow our logic and would like to proceed with that. So we will provide a kind of articulated recommendation from that. And even if we recommend denial, we will also say, but should you find, the means to kind of recommend approval, then we might even provide some conditions to help mitigate any kind of impacts of the development, that kind of thing. And so we would even articulate those so that if you would like to recommend approval, you can even see a set of conditions that you'd like to apply to them. And you can say recommend approval per staff's conditions, kind of when you're making the motion. One thing that is important in that regard is that needs to be a part of your motion, even if it was in the staff report. that there were conditions, there was conversation that you wanted to include the conditions. We can't actually articulate that you recommended to approve something with conditions if you don't state it in the motion. So, kind of what your motion is very important. And we can even, as another tool for you all, we can even provide motions sheets as we start and get applications to say, here are all the possible motions you can make, so that you could even kind of read from it. So we can kind of talk about if that's something that you guys would like. Yeah, anything to add?
No, I mean, I think it's just, when we are doing the analysis and providing you, response to both these criteria and just looking at the proposal, it'll be based on your policy documents, so the Unified Comprehensive Plan, and then your existing Unified Development Code. We'll point out where the request is consistent with those documents or where it may not. And so, as Rebecca said, we may provide an analysis based on what we're looking at, but there may be other conditions or things that you're aware of that may help you interpret or cause you to interpret those criteria different, that may lead to a different, conclusion than what staff recommends. But overall, we're here to support you. If you have any questions about what we write or want clarification, we're here to just help you and happy to assist.
All right, so special use permits are also legislative decisions, so they're handled very similarly. The difference is where a rezoning actually changes the zoning designation. A special use permit there's a use table in the Unified Development Ordinance, and it will indicate whether or not something's kind of a use by right. It's just allow, free and clear residential living in an R district. That's just, they're allowed to do that. There might be setbacks and kind of restrictions on the structures, but aside from that, the use is allowed to proceed, provided it maintains, residential character, and all of that. Then there on the use table, there are limited uses, and they're identified on the use table as L. And there are some requirements, supplemental requirements in the ordinance that say these are allowed, but you've got to follow these additional requirements. So it might say, a church or a place of assembly to go into an R district has to be on 2 acres of land. And so it's provided you meet that, you can do this. No other, special, aside from permitting and whatnot, no other legislative requests need to be made. Yeah. It can be administrative. Then you've got special use permits, and what that's in place for is those uses in that zoning district might be appropriate in some circumstances, and in some circumstances they might not be. And so this provides the governing body the ability to assess those on a case-by-case basis based on the particulars, based on the adjacent properties, and determine whether or not that use is appropriate in that particular application. So similarly, actually in the code, it just references the rezoning requirements. So exact same public notice requirements as there are for rezonings. And it's the same criteria aside from there are 3 kind of additional considerations, again, related to the particular context in which they're requesting that. And again, de novo appeals. So the additional criteria is the effect on usability of adjacent or nearby property, ingress and egress of off-street parking, and the effect on schools, public facilities, fire, and police services. Again, just because there might be, an effect, it is not necessarily, you're not required to recommend denial as a result of that. It's just asking that you consider those things as you're making your decision. And likewise, for both of these, we will ask, not only will we run through the criteria, applicants will run through them as well and provide for you their justification for how they meet all of those or how they impact them. And last up, text amendments. So a text amendment is a change to the zoning ordinance. The Unified Development Ordinance is adopted by City Council, adopted by ordinance, and that is what separates the city into zones. It also makes up several other, what a Unified Development Ordinance, different than a zoning ordinance does, is it's comprised of a zoning ordinance, but it also makes up land development regulations. So that's where you've got your stormwater requirements, your road specifications and things. So it's kind of all aspects of development, not just splitting the city into different zones. So here at the city, just by way of that's what the county had. And it's a pretty effective tool at kind of keeping everything consistent in one document. We have a unified development ordinance, and so a component of that makes up the zoning chapter. So to be able to, at the state level, a text amendment to the zoning ordinance is considered a legislative decision. So it's also, while there's not a specific property that applies to it, so there's no kind of mailers or signs or anything that are related to text amendments, there is still the similar 15 to 45 days to advertise those text amendments. And so again, that's the city council meeting that is that state mandated public hearing. And you all will hold a public meeting with a public comment period. And again, de novo review on those. So variances and special exceptions, this is not anything that you will see, but just wanted to make you aware. You will see concurrent variances, which higher arching. A variance is a request to kind of modify the conditions of the zoning ordinance. And so you see these a lot, with setbacks, sometimes with architectural requirements. Just if there's some reason why an applicant feels that they can't meet the strict interpretation of the code, they might ask you for a variance. Now, a variance by definition is the purpose of the variance process is a relief valve to prevent what's called a regulatory taking. And so if, by example, if you got a property that is bisected by a stream and there's a 75-foot stream buffer on either side, and so the only buildable area of that property is in the required yard. So it's, they've got a setback. So effectively they can't build what that property is zoned for, what they bought the property for potentially. The conditions are going to be unique to that property. But that's the case where the Zoning Board of Appeals might, it's an opportunity for the Zoning Board of Appeals to prevent a regulatory taking, meaning facially, there's no problem with that. So there's a facial challenge to an ordinance, and then there's a regulatory taking. Facial is the ordinance, no matter how it's applied, it's unconstitutional. Regulatory taking is, or an as applied challenge is facially, there's not a problem with it, but as it's applied to that particular property, it has created a taking. And that's unconstitutional. So without just compensation, so that the variance provides a relief valve for that regulatory taking. We didn't mean to take somebody's property. It's an opportunity to set that right before it has to go and be litigated in court. So just wanted to give you that. That's kind of something that happens separate from your review as far as it being a quasi-judicial decision. But just wanted to give you kind of a little bit of background on that. We've also got administrative variances, and so those are more minor. They're limited in kind of scope of what we can do administratively, and so those are administrative variances to not rise to the level. And it does have a separate set of criteria. No, I did not put the criteria in here. There are also concurrent variances that you all might see that come concurrent to a rezoning or special. And those can be heard and recommended by you. So this is just the process. There's a required public hearing, different than the 15 days for legislative decisions at the state level. There is a minimum notification of 30 days. There's not really a maximum, but we say 45 because the state kind of muddied some of the definitions of what's quasi-judicial versus what's legislative. So we like to kind of meet both standards with that time period. And then there are just some standards, both in the ordinance and at the state level in the case of rezonings, where if there's a denial of an application, then it can't be applied for again for 12 months by the local ordinance, and then that can be reduced down at special request. And then appeals, can be made within 30 days of that final decision of ZBA. So some constitutional considerations as you're working through these, procedural due process. So this is mainly going to be handled by staff. This is making sure we provide proper notice, that meeting agendas are posted in accordance with the open meetings law and things, because we want to make sure not only is the public properly noticed, but both the public and the applicant receive due process. These are the kinds of things that can nullify decisions and things if they're not made correctly. Substantive due process, if decisions are arbitrary and capricious. So we want to have a rational basis based in the public welfare for our decisions. Equal protection. So we want to make sure we're not like a good case for this is code enforcement. We want to make sure we're not treating one group or one property owner or one offender differently than other offenders. Takings, I just kind of talked about the physical and the regulatory takings. Freedom of speech, we see that a lot in the, you'll see it come through in the UDO, adult entertainment, religious expression, as well as signage. We see that we can't regulate signage based on the content of it. So you'll see a lot of the content within the sign ordinance is neutral. Likewise, if you see a sign out that advertises a barbecue and it's a steak joint, we can't care about that. So, various things like that kind of impact our work. And then this last one, it will probably not rise to kind of in front of your desk, but just something to make you aware of. So there's this, it's called RLUPA, Religious Land Use and Institutionalized Person Act. And what it says is we cannot impose significantly more burden on religious institutions than other places of assembly. So theaters, other, movie theaters and things like that. We can't say that religious institution has to be on a 2-acre parcel, but not say the same for a movie theater. So they have to be, at the very least, the religious institution has to be equally as regulated, if not less. Any questions so far? I know I'm kind of reading through.
Mhm.
All right. Meeting procedures. So you've already gotten a crash course on some of these. Regular meeting agendas, this is pulled from your bylaws. So this is the structure of all of your meetings. And so we will just populate these as applications, are presented to us. And there are also procedures within the bylaws. If there's anything that you all would like on the agenda, there's I think a minimum 7-day notification to staff, potentially working with other commissioners to make sure you can get a majority. Via email, you all have planning, there's a planning commissioner email, and then you all have your own Mulberry email accounts. You want to make sure all of your communication goes through there. If there's some sort of like, let's schedule a new meeting or something, make sure you have those, all those on there, through those accounts. The purpose being, it's subject to open records. We want to provide the public access to those should they ask for them. And so we want all of that communication. You'll never be discussing kind of particular cases or anything, either verbally or via email, but kind of if there's some sort of legitimate reason to be kind of communicating as a group, then making sure you're doing that through those email addresses. And that's a place where you can kind of suggest various agenda items for that process. So I kind of review this as far as what you'll do ahead of meetings. You'll get those packets, and it'll similar to this. You'll get virtually the agenda and any kind of supporting documentation, including any staff reports. We ask that to be prepared for the meeting, that you kind of review that in advance. If there are questions, you can give us a ring. you want to refrain from having conversations with each other. But if there's a question that one of you has, it's likely that all of you might have it. And so that might be a clarification we can provide, or it could be a part of our presentation, or maybe there's an error and we can kind of fix that before it's too confusing. So please feel free to reach out to us as there are questions or as you're kind of digesting the material. So you consider the request and the criteria that we've kind of outlined for you in that staff report, and then ask the questions.
Can you give some guidance on communication with the public for the applicant?
Yeah, there's probably some sort of policy we will, establish as a city, but I think a good rule of thumb is allow staff to handle that. If you get emails, certainly there's a public email where they can email you various things. And we could provide those, as a matter of public comment as part of the record and whatnot. But I think a good rule of thumb is refraining from answering necessarily. And if there is something that staff needs to answer, then that's something that we can follow up on.
One thing I think would be good is if, you always do want to follow up, right? If you do, copy myself or Rebecca, and then if there may be times where we will give you the answer to respond so that it comes from Planning Commission.
Okay.
But I would just say even on the response, copy us so that way we can all be in the loop for communication.
Right. Okay. So generally it's one-sided. If somebody wants to, if the community wants to discuss, it can be one-sided to us.
It can, yeah, it can be. The other thing, and I'll verify this, because we've got that, the Planning Commission email is a distribution list. We can make sure, and that'll be the one that's posted on the website. We can make sure that distribution list also has staff on it, so that if it's coming to you, staff are also seeing it.
Right.
And if we need to respond, we can.
That's good.
Okay.
A quick question myself. So we do have our Mulberry email addresses all set up already. So you said we're going to have 2 email addresses?
So you'll have the Mulberry, that Planning Commission at mulberryga.gov, that is kind of the public facing. It directs to all of your Mulberry individual emails.
Yeah.
It's just a way that everyone can email all of you at the
Okay,
same
so
time.
that is a public
Yes.
email. Okay, and then there'll be a secondary one for.
The secondary one is the one that you've probably been checking where it's your, where it's your name.
Okay,
And so that's the account that you're actually checking when the public, or did you email the Planning Commission email, or did you email them individually? Okay. So when the public or we email the Planning Commission at mulberryga.gov, that's going to distribute to all your individual mailboxes.
Okay.
So you're not having multiple emails.
so what has that been released yet? I haven't seen it myself.
No, I don't think it's anything that we've
Okay.
posted online yet.
Okay,
And generally it's just a group, right? So,
Yep.
so you can respond as an individual, but it's just a group email that just has all of you in there. Like if
Okay.
you ever go into Outlook, you can click on the group and it'll expand it and
Oh,
it'll
okay.
show all of your individual emails.
gotcha.
But that, like Rebecca was saying, it's just a way for the public to communicate with all of you at one time through one email instead of copying all of you on the same email.
Right.
Okay,
Yeah.
makes sense.
Rebecca?
Sure.
Hey, I got a question. So as far as when you guys send the packet out to us before a meeting, is there a minimum number of days that'll come in? For instance, if we're looking at something, I think we're going to need a sufficient amount of time. So, I'm hoping it's not like the day before or something like that, because, a lot of this stuff we're going to need at least a week to look at, and in some cases probably longer.
Yeah, absolutely. So I don't think we've put a time period in the agenda. The standard is going to be a week. What we can also do with a more complex case, we're kind of, from the first one on, we're going to be kind of working from one to the next.
Right.
So because we're working on that deadline, there might not be the ability every time to get a staff report out early. But what we would be able to do is the application is due sooner than that. So we could even provide for you applications in advance, just so that and we will also post them when it's ready for it to go public. Like we've already done a completeness review and everything. We will also post those as upcoming applications on the website as well.
Do those give out 30 days in advance, just like when the sign goes up or in advance of the sign?
It'll be before the sign because we'll need at least a week, if not a little bit more, to kind of do a completeness review, request any updates from the applicant before we want to, commit to having a meeting on that item. So it'll be at least a little bit before that. It might not be ready for consumption yet, but yes, yeah, there'll be some delay. Any other questions today? So just at meetings, kind of the expectation is, being respectful, maintaining appropriate decorum. You can ask through the kind of public comment process, and we'll kind of guide you through the script, process, but you'll have opportunities to ask questions of staff, of the public, if not necessarily at the public comment period, even for an individual item, but you'll be able to kind of call members back up should you need some additional information from them and kind of ask them questions. You all can maintain a dialogue that specifically occurs after you make the motion and the motion's on the floor. Then from Robert's rules, then that's kind of the time for you all to have discussion with each other. Before then, you're kind of collecting facts from other sources, and then you guys can start and have the discussion after the first and the second and the motions on the floor and kind of belonging to the body. You all make recommendations, and then we will transmit that through the form of a staff report to the city council when the time comes. Kind of already went through staff where we've got the conditions, and we base our recommendations based on kind of the policy documents and that criteria. Also with conditions, with questions, if you uncover, something that an applicant hasn't addressed, or you all have questions, you can either, you can request as part of your motion that they address something, or provide documentation or look into something before the mayor and city council meeting. So there's a set of like guidance that you can provide if there's something that you didn't have to kind of make a full benefit of a decision, that you can either require through the postponement, or require that they do it before, first read before city council, or whatever the case may be. And you can also, we will provide those conditions. You can add to them too. If there's something that came up that is an impact that you want to mitigate, those can also be added. We'll want to make sure that there's kind of a rational nexus between what that condition is and what the request is, but that's also something that you can add. Tools, of course, what you've got in front of you, kind of the meeting script to help walk you through. And then on the right, those are the motion sheets. And so if these are something that you'd like, what we do is we identify, we kind of go through the format of the entire agenda in this chart form and indicate each of the potential, generally potential actions. And then we highlight the one that staff's recommending. And then usually provide the criteria for you as well, so that you've got those to cite in your motion. I talked about if conditions aren't in the motion, it's as if they didn't exist. And then you've got your no comment or no recommendation if you don't make one within 30 days.
And I think it's important to note on that 30 days, if it's before you and you want additional time to consider it, or you want the applicant to come back with additional information, you can table this request to the next meeting, and that will prevent it from automatically being transmitted. So you can say, hey, you know what, your site plan isn't consistent with what you're requesting. You're saying you're going to do this. Let's see a revised site plan, and we want you to come back before the planning commission before we provide mayor and council with a recommendation. So we're going to table this request until the next planning commission meeting.
Can you give me kind of a practical application of that no comment when that would?
That's really, it's kind of unintentional in a way. It's
Right.
if for some reason you're at a stalemate or, it's to prevent kind of an applicant kind of being, and the public, because if planning commission is continuously tabling
Right.
something, that's a disservice not only to
Sure.
the applicant, but to the public, because they're having to kind of continue to come back if there's a case that they're opposed to or extremely supportive of, then they're going to feel like they need to come back to meeting after meeting after meeting. So it's kind of prevent that cycle,
Mhm.
and be a little bit more definitive and respectful of the public following a case.
And would that really, I guess, and this is probably a more procedural question, would it be a motion for no comment? Or if you can't get a majority, because I know it doesn't move, you have to do motions before you can move, and you have to get a majority before it moves ahead.
Yeah. So this is saying if you don't make any kind of a motion, it's going to move forward in that
And it
manner.
just takes it out of our hands
Yeah.
for the city councils. Okay.
Yeah.
Got it.
So you've seen kind of the first half of this, and articulated the public comment period. That's just general public comments, and each member is allotted 3 minutes for that. That should be public meetings, but it's also public hearings before the city council. You're allotted, the public speaking in favor is allotted 10 minutes, and the public speaking in opposition is allotted 10 minutes. And so you all can vote if there's a long line of people who want to speak in favor and opposition. You can vote to extend the time on both sides. Or you've got in your bylaws a provision where if there's additional comments, then they can submit those in writing for the record. So you can kind of choose how to handle that, or both even.
Sure.
But you need to do it equally for each side. And staff, we will provide you, that guidance through not only kind of verbal answering questions, but through those staff reports, through the review and kind of. We will start talking to applicants through usually like a pre-application meeting. And so in talking to them, we will guide them to the policy documents. We are, for those applications, we're kind of working on refining the documents that we've got now. And as a new city, there will be a much more, Mulberry specific policy document created that takes into consideration, housing goals, land use goals, transportation, all Mulberry specific, because right now what you've got is kind of a county policy. So that will guide a lot of the decision-making process is that document. And then of course we serve as the secretary, kind of creating minutes. So we will create action minutes from this meeting, articulating the motions that were had, the votes that were had. It won't go into a lot of detail about kind of the details of public comment. It's just going to kind of summarize, these are the general public sentiments, that kind of thing, but we won't necessarily list out verbatim minutes. And those will be provided to you in your packet as well, so you can review those. Various motions from Robert's Rules of Order. Again, you've already got a crash course on this. So chair calls for a motion. There's a motion that's stated. So you might say, I recommend approval of the rezoning with staff's conditions. Then somebody seconds. And then discussion is had. There might, as a result of this is, I think, kind of a lesser followed part of Robert's Rules that's a good process to know, because it has been known to happen. If you guys get into discussion and there's a desire to add a condition, let's say, that wasn't part of staff's original conditions, and you guys all kind of generally agree to it during your discussion, that motion now belongs to the body. And so the tendency, from what I've seen, is for the motioner and the seconder to be like, you guys good with this? Okay, let's be good with this. What, from a procedural standpoint, what you need to do is there needs to be a motion to amend the original motion, a second to amend that motion, a vote to amend it, and then you can go continue discussing that original motion with the amendment if it passes, and then vote on that. So it's kind of bookended by the original vote, but you've got to have that vote to amend the motion because it belongs to the body at that point. So then that vote, announce the result, and then we will record the motion in the minutes. Just kind of general, be familiar with the ordinance. I mean, you don't have to read it line by line. We will provide you all of the kind of context for these decisions. If there's a concurrent variance, we'll provide you with the section that they're varying with the criteria and the analysis of all of that. If there are conflicts of interest and you need to recuse yourself, then you can't be part of the conversation. So at the beginning of that, you will announce kind of that you've got a conflict and you'll actually need to leave the room. And then we can, come and get you afterwards.
And let staff know in advance if you are concerned that there may be a conflict of interest, even if it's just a perceived one, and we can kind of give you guidance, whether, from our level or in consultation with the city attorney on how to best handle that.
And we've got this in a little bit more detail. So, interacting with the public outside of meetings. So, of course, we want to be careful about kind of having meetings, among the board. So having those discussions, seeing each other and at a barbecue is fine. Talking about a particular case is not going to be fine. You want to make sure that we're in an open meeting and the public got an opportunity to kind of hear your deliberation as a part of that. Even for legislative decisions, it's just kind of best practice. And so as far as communication with the public, we'll develop more kind of city specific guidance on that. But at this point, you're representing the city as a member of the planning commission. Be respectful, kind of uphold the bylaws, and we're here for general guidance.
And social media posts can be used as record in litigation. So that's why, even though it might be tempting to engage in that public sphere, it's really best to just be receptive. Thank you. We'll look into this. We'll follow up, but really don't opine on anything because, you're representing the city. You want to make sure that you aren't giving an opinion outside of the public meetings and really just kind of respecting the process.
But also recognizing you all have, individual, rights, and by being on the planning commission, you're not giving those up as well. Mulberry, the zoning map. So this is the city split into zones, and so when we present to you an application, we'll have an exhibit and a map corresponding to it that would identify that parcel and what the existing and proposed zoning is and all of the details.
Have the maps been upgraded yet?
Are the websites
Updated yet?
for the annexation?
Yes.
This one is not.
Okay. That's what I was saying.
Not yet. We'll
Okay.
wait on the legislation to be signed.
Gotcha.
And
Okay.
once the governor signs the legislation, then we will ask for the maps to be updated to include the new areas.
Okay.
And then this is the future land use map from the comp plan. So this is that more policy level. It doesn't likely today match the zoning ordinance. It can, in a perfect world, what we want that property to be, the zoning should match it. But this is what we look to. There's a general tendency for from the government side not to allow an applicant to come and make application to come into compliance with that. Not that it has to happen that way, but that a lot of times is kind of the tendency. And then we make decisions hoping that they're consistent with kind of our future vision for those parcels and the character of those parcels. And so we'll do an assessment of that character area for each of the rezonings and special use permits too, with regard to what the map and the comp plan say about that. Do we want to go into case studies, or are you guys feeling on time?
I'm fine. Everybody?
I'm good.
And we can kind of chug through these. This is not going to have the level of detail that you will have on typical rezoning and special use permit requests. But we're saying, assume there's an RA 200, which is an agricultural residential parcel, is requesting rezoning to C2, which is a much more intensive commercial district, general business. So it's a total property of 1 acre. It's a long 85. Abuts C2 and T and D parcels, and it's proposed as a full service restaurant. And then the second petition for consideration is a similar rezoning. That's the same thing. So this is the set of criteria that you would consider in that rezoning. So, whether it will permit a use that's suitable in view of the development of the adjacent nearby property, whether it's going to adversely affect to the existing use or usability of the adjacent properties, future land use map, impacts on schools. So just from everything that we've talked about now, kind of what kinds of things would you all consider with a case like this, or what kind of more information do you want, since it is pretty scant information? What additional information would you want as a result of it?
Traffic study.
Potentially. There. You want to know more about while those adjacent properties are zoned, do you want to understand a little bit more about how they're used, different
Yes.
potentially than their zoning? Any kind of site plan characteristics, elevations, parking, circulation, which you'll get from a traffic study, how many curb cuts do they have? What kind of impact does that pose?
Yeah. And if there's one commercial property on one side, is there any cross access between the two? Is there,
Yeah.
what kind of screening, if it's a drive-through, or, they have speakers, is it going to disturb the neighbors in the next door?
Yep.
Residential, sorry, subdivision is there, so there's.
Yeah, cross access. There are requirements in the code for kind of reducing, especially on, with it being adjacent to 85, it's more than likely on a more major thoroughfare. So from an access management standpoint, the more curb cuts are along a high traffic volume road, the more slow down because of cars going into individual curb cuts. So there's a desire in the ordinance to reduce those and consolidate them so that there are fewer opportunities for those slowdowns. So are there opportunities for this individual property owner to consolidate and work with the adjacent? Can't necessarily, depending, we might not be able to make them, but is there something that they're willing to do?
Yeah.
Any conditions you'd recommend or any guidance to city council that they need as a result of it?
Could you flip back to the case?
Yep.
Slightly different. One
Oh,
is totally surrounded by RA 200 and one has some commercial and other the candy.
Oh, you're right. Yeah. And then also, how would you consider these two differently? Thank you for that nuance.
First one is almost, I don't want to say mixed use, but it does there's already a commercial next to a neighborhood. So, you might look favorably to approve it for the first one, but the second one, if it's going to be all around your residential, then you got to start looking at how that's going to impact those, the residential. And
Now, when it says full service restaurant, that means sit down, or is fast food considered full service also?
Not in that, I mean, I think those are good considerations as we talk about restaurants. I mean, technically, yeah, for a full service restaurant, it is sit down.
I think it's just a matter of what, does it have a drive-through? Does it not have
Yeah,
a drive-through?
ask them those
Are they
questions.
gonna be
Yeah.
doing takeout?
Yeah.
Yeah.
Air scrubbers for the smell.
What's that?
Air scrubbers for the smell of the cooking.
One thing that could change based on the particular context, so you've got that last. Oops. There you go. The last criterion, whether there are other existing or changing conditions affecting the use. So in this second one, where it's surrounded by all RA 200, you might say, oh, of course, they're, adjacent agricultural residential. Of course, this isn't appropriate, but maybe in the policy document, it envisions this to be some sort of commercial area. So that might be where you consider, you know what, as a city, we've identified this as an area that's different than what is there now. And so that might be justification for approval for something like that.
Another thing I think we need to know, excuse me, is, lose my voice here. You know, how big is the restaurant gonna be? How many seats? Is it gonna seat
Yep.
20 tables, or are they gonna just wanna seat 50 tables?
Mhm.
And that's also gonna change all kinds of parking and parking regulations and
Yep.
everything else. So we would need, really just, that's just information we would need.
Yeah, I mean, you would have to have a site plan, potential elevation. I mean, you'd have to see a whole development. I don't want to say full submittal, but pre-submittal.
Yeah.
Of sorts to know exactly what is being planned and what is being looked at.
And to, with your familiarity with kind of CDs and things, construction documents. So there is a level of completion you will see in front of you. It's going to be a site plan. It's probably going to have the parking counts, some sort of, we'll do an initial kind of code analysis to see if we can identify any things that they're deficient in, so that they either fix them or ideally just kind of fix them and comply, or request a concurrent variance. But they're not gonna get to the level of necessarily, designing and doing site grading and things. They'll probably do some preliminary studies and having a basic understanding, but they're not going to go full, civil sets at this point. So there are also, after kind of the approval process, there's also potential that they kind of alter their plans based on, the realities of development. And so just for your information, we've gotten the ordinance kind of a set of criteria of what warrants having to come back before you, because it's such a substantial change that you need another look at it, or that it's something, this is small, this is the realities of this process, and they can kind of tweak things here and there.
Another thing I think we want to consider too, is this gonna establish them that can be serving alcohol? And if they're gonna be serving alcohol, is it just gonna be table, or is there also gonna be a bar? Because then if there's a bar, you got a restaurant that's open till 2 o'clock in the morning. Versus say 10 or 11 o'clock at night.
They have, different implications for adjacent.
And that can affect neighboring property owners also. You got people partying at 2 o'clock in the morning.
Yeah.
It can cause some problems.
We've also got, there are these layered requirements. There's also in the alcohol ordinance, distance separation. So, if they haven't done their it's certainly a question that we would, pose, but if they haven't done their due diligence and to know that there's a church adjacent, and they go all the way through the process and then come in and apply for an alcohol license, they're not going to be able to do it if they're, not meeting those distances and things. Let's see what else. I think we've got just, special use, permits. Zone C2 to allow for a mechanic shop. It's on half an acre and abuts a residential properties on all sides. Within that use table, mechanic shops are special use permits, allowed by special use permit in the C2 district. So what kind of things do you consider in this case?
I mean, there's different types of automotive repair also. Is it an automotive, is it a body shop? Is it a mechanic shop? Are they gonna be building super race cars? Like, what's the facade gonna look like?
All the things y'all will tell us.
Yeah, I mean, you've got, you know, what they're doing with their,
Is there enough storage on site? If it's only half an acre,
Hmm.
how do you handle employee, customer, and inventory?
Well, yeah, if they're selling tires, they're gonna be storing tires. They're gonna be also handling used tires. Where they can dispose.
if it's a body shop, you've got all the damaged parts they take off. They've got to have
Yep.
dumpsters for that. So there's a lot of different things, like he said, depending on which kind of,
Yep.
talking about automotive place is it? Is it just a mom and pop oil change place and brake jobs and maybe some tires? Or is it, you know, more of a chain or something that just, you know, another NTB or another Firestone Tire Center that just wants to, you know,
And this is a good example of where you may look at it and say, you know what, it's already zoned C2.
Mhm.
That special use permit would allow them to operate a mechanic shop here. So it's consistent with, you know, potentially policy documents or goals. But you know what, it's half an acre, it's surrounded by all residential. This may just be a case where it's too intense of a use for this site. That's kind of where your discretion and oversight comes in. Because just because it may meet the criteria at a technical level doesn't mean the on the ground conditions necessarily apply.
And to your thoughts about user, so we actually can't condition projects or applications based on the user. So this comes up a lot with like fast food restaurants. There are some fast food restaurants that people will line up in support of in droves, and there are some that aren't that way. If a fast food user comes in, gets an application approved, it could flip to another user, no problem. So as you're making decisions, you want to not think about the individual user. You want to think about the use and the particulars of the use and the impacts of the use, and not necessarily think about the user.
You can think probably 10, 15 years ago when Walmarts were moving into different neighborhoods, you used to see a lot of opposition to a Walmart being brought in, but you really can't deny it just based on that end user. So it is kind of.
Yeah, and you don't want to approve it based on the end user either, because that could change.
They can change.
No. And then something with the rezoning one, you know, because it's potentially C2 in a C of RA 200, there is this concept of spot zoning that isn't allowed, where you put a different zone in the middle of a different district, with the exception of if the policy document warrants it, then there is justification for that changing zoning. So in the situation that I talked about, policy document is wanting to go in a different direction from what is there today, from a use standpoint, from a zoning standpoint, that is a support from a policy perspective to be able to apply that different district. So that was everything. I think we have to go to training. Any other questions?
Great. Thank you.
Many more situations that come up, you know, where we'll try and kind of give you a baseline and.
So those two were you gonna actually review? Okay, so those were just made up then.
Yeah.
Hey, you never know, right?
Okay, thank you so much.
Yeah, thank you.
That's very helpful. The next item for new business is as follows: TA 2501, review of text amendment to the Unified Development Ordinance related to the architectural standards for single-family and multifamily residential uses. Staff, I'm going to ask you to present the staff analysis and your recommendation.
Sure. So we have assembled this set of text amendments. Everything in your packet is entirely new to the ordinance. So none of this exists today. It's not amended from any kind of strike through of what's in there today. So we've got it separated into two different components. One, standards for single family uses, and that's detached, attached, and industrialized homes, kind of all treated similarly. And then separately for any kind of multi-family uses. And so Mulberry is a new city, and from a policy standpoint, there is a desire to kind of regulate some of the architectural requirements for and provide kind of a minimum standard for any kind of residential, either single family or multifamily coming through the city to kind of support the vision of the community and the character of the community. So I'll kind of outline how this works and the general design requirements for each. So first, I'll talk through the single family use requirements. So we've got requirements for exterior finished materials, requiring that they be primarily brick, stone, or other masonry, glass, wood, or cementitious fiberboard. So that's essentially hardy plank is the name brand, is a name brand version of that. Other materials such as vinyl may be used only as trim or accent materials. And then there's a requirement for exposed foundation walls to be some sort of, at the water table, some sort of masonry material. Simulated masonry products would be prohibited. They need to be kind of full or half depth brick so that there's actually, a masonry process going on and not something kind of applied as a sheet or something similar. And then limiting metal to 10% with a set of acceptable architectural metal requirements. Then we've got some architectural elements, limitations on kind of the number of colors, so that there's not kind of too many colors, kind of causing some too much busyness on the elevations, and then giving exceptions to those protrusions, so like balconies, decks, and things. A maximum percentage of the front facade it would be made up of garage doors, so that there's not too much of a focus on the garage door, or it's set on a different facade. Requiring that they're offset 5 feet. Just a general requirement that there be some sort of architectural interest in modulation, and that can be accomplished through some, bay windows, turrets, porches, and that kind of thing. Mitigating the repetition of identical facades, and that's not necessarily, there can be really well done, where there's a change in material or a change in color. So it's not necessarily limiting some of those differentiations, and it defines what represents a differentiation from one facade to another. That there's a minimum percentage of facade area that's dedicated to windows, and kind of requiring that the mullions or the dividers in those windows be real and not kind of their simulated muntins, which are between the panes of glass within there, just representing a little bit higher quality window. Some requirements for roof materials and roof pitch, and so then under number 10, what we've got to provide almost a menu of options to allow individual builders, homeowners, or whatever the case may be, the ability to meet some minimum standards, but not have everything kind of prescriptive. And so every unit must have at least one feature from each of these categories. And so we've got, and they can be double counted. So private outdoor space, with porches, balconies, terraces, making that up, architectural projections, like bays or turrets, various roof kind of elements, whether that be a gable, a terrace, cornice detailing, and then a facade change, and it defines what could count for a facade change. And then a requirement for recessed windows so they're not kind of flush with the walls. And we've got some additional kind of site requirements related to circulation systems. And then utility requirements. These are particularly common in townhome developments, where you might see a bank of utilities on the end unit. And so this requires that each of those be individually fed and metered. Then multifamily, we've got some similar, where we've got the similar primary building materials and the similar water table, as well as the same roofing requirements and color requirements. And then these are the ones that are kind of distinct to multifamily. That 60% of exterior materials on facades visible from public right of way or adjoining residentially zoned lots shall be brick or stone, and it needs to wrap the corner to give the appearance of being applied. They've got to be facades have to be broken up through materials and offsets, and roof lines varied. Minimum heated floor area of 800 square feet per unit. Identifiable building entrances, and then from a quality, kind of an interior build quality, a sound transmission coefficient minimum, so that there's not sound transmission between units. And then again, the same recessed window system. So really, we kind of proposed a large set of requirements that, again, are too prescriptive. So something that you could either kind of pull back from if there are some that seem like going a little bit too far. But this is kind of a menu of options for design standards that can be applied to all residential products.
I will now entertain a motion in a second to open the floor for public comment. You get a motion?
I'll make a motion to open for public comments.
Second.
I'll second it.
Now it's time I'll open it up for public comment.
Where is the city of Mulberry gonna be? Where is the city of Mulberry gonna be?
Where's the city of
We're in it.
Mulberry?
I was right
You're
here.
in it.
I mean, this is it here, right?
Well, it goes on the other side of 85, Hamilton Mill to Ridge Road, north to the county border. South on this side goes north to the county line.
I just,
There's an extensive map on the
yeah,
website.
I've looked at the map and all, but nobody could. I call Lawrenceville and they don't know anything.
There's an actual map in the foyer.
Yeah, I'll go grab it so you can see it.
Yes, ma'am.
Is there a location anywhere where a resident can type their address to see if they are in the city of Mulberry? And the reason I ask is I have friends that live on the other side of Decula Road, and they said, I told them that they weren't in it based on the map that I saw. Well, it turns out they were. And
There is,
Yeah, we can-
it's on the website.
We can work
because I
with
looked
that.
at the website,
There's a
it didn't-
link.
There's a link on the website. It specifically said, am I in the Mulberry?
I clicked on that and it took me to a map and I
Oh,
couldn't.
okay.
It
I
took
never
me to
put,
this map.
So what we're also doing, right, is we're gonna have a GIS link up that kind of shows in where you can zoom in and put in the address. We're getting ready to kind of have that out. But this kind of shows you, the best way I'm learning, right, is anything south of Brownston that's in Gwinnett, right to the county line of Barrow, cross the county line of Hall. That's kind of the depth of what our city limits are, right? We have along 85, we have, and with the annexation, we'll have the full interchange at 120 on both sides. And then if we work on like back through Flowery Branch, the bridge crossed 85 on Flowery Branch is ours.
Providence Road.
And then going all the way again back up to,
Now, where's Mulberry, the schools on that map?
the school is down here somewhere.
That's right. It's down in.
It's 5.
That's
Five-
right.
5, yeah.
I believe it's in 5, yes.
Yeah.
It's in Mill Creek's,
Now Mill Creek,
Mill Creek is in the
Creek's right up
pink.
here, right
Yeah,
across
yeah, yeah.
Brownston,
Yes.
Brownston Highway, right? So here's Brownston Highway.
Yeah.
Here's 85.
the Seconders on the other side in the dark blue.
Yep, Signature's like right over here in this corner.
I believe then you have the two elementary schools. There's an elementary school.
And middle school.
Yep,
Yeah.
elementary school, middle school.
All
We got two high schools, two middle schools, two elementary schools.
Yes.
But they all stay with the county school board.
Yeah.
We have no control.
Yeah.
And in the interest of time, we want to discuss this particular section. So we can answer all those things offline. Unless you have something either pro for the amendment or against the amendment. Okay. And then I want to open it up for discussion amongst the commission.
If you'll close the public comment period.
Okay, all right, yeah. All right. No. Show me some grace as I learn my first one through here.
You're doing great.
Yeah. It's been a long, long time.
Doing great.
Let's see here. Okay, thank you. Listen, okay, I need a motion to close the public comment period.
Make a motion to close public comment.
Can I get a second motion to close public comment?
Second.
All right. We now have a motion and a second. I will call for a vote. All those in favor of closing the public comment period signify by saying aye. Aye. Any of those say nay? No nays. Passes 4-0. Thank you for the public comment period is now closed. I will now entertain questions from the staff regarding this request. Please limit discussion amongst the commissioners after the motion on the floor. Okay, this is where we discuss.
Yep. you
All right.
got
we've
it
got
all.
to the next one.
Can I make a comment in this?
Please.
So I'm not sure what the objective is to get this passed tonight or what, but my concern is that we probably need more time to review this because I think that there's a lot of standards in there that's going to affect the city for long periods of time. And, we really need some time to review this is my personal opinions on it.
I concur.
I'm gonna agree with Chris on that. There's a lot of, if we just adopt this tonight and we're gonna stop.
I mean, I'll say this, I like that it's only 4 pages.
Yeah.
Short, sweet, to the point, but I tend to agree that
I just
Yeah.
think there's some areas in there that should be discussed and
Yeah.
understood a little more,
Jamie.
I do understand and do not disagree. I just want to make the comment of stating that, though whether you choose to table and adopt later or at any point to review, there's always things that you can bring back to staff for changes at a different point. So I don't want you to have the understanding of this is the end all be all, right?
Sure.
Just the first text amendment. There will be other text amendments in the future. These are just some basic standards. So one thing I want to make clear too, right? You cannot annex or have property come into a boundary without zoning. So part of the reasoning for doing this is when the city limits were created, the only way to do this was to adopt the zoning that was already in place. So this is just the first of many that you all will see before you of text amendments to update what was already zoned through Gwinnett County that we would mold and craft to make our own Mulberry zoning. But make your decision as you will. I just wanted to clarify what this is when it comes to text amendments and how they work in the future.
Okay, so what you're saying is in summary, just so that we understand clearly, is that this is the initial from the ground up building requirements. But say we could come next month if there's something that we wanted to strike from the language or add to the language with regards to that, just in our new business.
Absolutely.
as it pertains to single
As it
family.
pertains to
I
single
mean,
family
this is
and
not touching any kind of
Commercial.
other commercial, industrial, or anything like that.
It would come to council action, but they're a recommending body to you all. So the way this would work is, so this is just an example. Let's say that you all want to take more time to understand what the text amendments are.
Mhm.
You would go to the table, right? You would come back with more information, more outlines, and then you come in and cross out or add things to those standards and ask for staff to review them
for us to either adopt and then you all recommend whatever to mayor and council for a decision.
Say that again now. Lost me a sec. Is that, are you,
That's why I kind of worded it weird, because
Yeah.
I don't want to make this seem as a suggestion, right?
Right, okay,
'Cause
I
I'm
got
not, I'm not making it.
so let me
Staff
paraphrase
kind of
what
like-
you're saying.
Yes.
Just give you two things. Number one, we table it, nothing happens.
Correct.
Number two, we vote on it as it stands, and there's a vote as it stands, that can be struck through in the next meeting or concurrent meetings thereafter, that if we find things that we do want to change.
If you vote for it to be approved, it will move on to mayor and council for adoption.
Mhm.
But if you have suggestions that you would want to change, that's something that we can bring back to you. You can table it and do the same thing. It just would not move on to mayor and council until you approve or deny.
Chris, did you hear everything?
I can, and honestly, in looking through this, I see things, I've saw things that I would recommend changing already, and I haven't been able to thoroughly look at it, or at least I would make a recommendation too. So, I'm not voting tonight, obviously, but I think
And
we need time.
certainly, regardless of whether or not you postpone to at the next meeting or make a recommendation, I think letting us know now kind of what those are, even between now and even the council meeting in either case, or in the next planning commission meeting, because we can make those. If you table it and it's going to come back before you, sending a note to staff, hey, I looked at this, I'd like this change, then we can make those adjustments, and it's not something that you're making on the fly. That's
Right.
when errors are more likely made, because we're doing it on the fly. So whatever happens in between now and kind of the next public look at this, that feedback is really helpful.
So if we table this tonight, then we review this again in 30 days. Is that correct?
Yeah, you'd postpone it
Okay.
to.
My opinion, guys, is again, even though it's only 4 pages, I say we go through it line by line, each of us. And I've been a contractor for a long time. Chris is obviously a commercial contractor. I say we take time personally and just look it over.
Mhm.
I mean,
So
30
are you
days.
making a recommendation or making a motion
I'm making a recommendation.
for,
Well,
Go
go ahead. Go ahead, Chris.
I was just going to say, to that point, Rebecca, where you're asking, for things, like one of the things that I sort of stood out to me right off the bat was, we're making recommendations and trying to keep things in the city as, high end and nice. And, one of the first things I see in here is the roof slopes are between 3 and 12 and 12 and 12. A lot of your high end homes now, you're going to have steeper than a 12 and 12 pitch on the front elevations of eaves. So you're automatically restricting some architecture of some higher end type stuff with this. I would at least say a 16 and 12. And again, I still need to go through all of them, but.
Certainly.
Just to make sure that I understand for this, so the design standards apply to new development only, or do they apply to changes to existing?
That's a good point. It's not articulated in the draft itself, but yeah, the idea would be good. It applies to new construction, from the ground up. We can talk about also, are there certain standards in here if you're gonna do an addition or something? Do we want certain standards within here to apply, or do you want those additions just to kind of be able to continue on? So I think even we look for guidance on that.
Mm-hmm. Seems like there should be some standards at least, even on.
Well, 30 days is not a long time to wait to review this again.
So is the recommendation that we as we redline this and kind of go through it, that we send this to staff ahead of time, or what would be the way that?
So yes, if you want to go through and whether it's notes or markups, if you'll go through and give us your feedback, and, you know, you can send it to Mackenzie, and then we can compile all of it. We've also got, some other folks kind of reviewing it in the meantime. So what we can come back with, kind of a consolidated set of changes, and that would be based on all the feedback. You know, if some of it's conflicting or something, we might have to say, hey, we got this
Sure.
comment in this comment,
Yeah.
like, let's reconcile them in the meeting. But yeah, that's what we can bring back is a revised recommendation of what this looks like.
Okay, so I got another question. So this is a hypothetical. So could say me and Chris meet up and review this ourselves, just, is that legally, or we able to do that, or no, we can't?
Yeah, do
Okay.
it.
That would be nice to never three more of you together.
Okay.
Yeah.
Just want to make sure.
Then you have to record it, take notes.
Now, could all five of us,
Meeting.
could all five of us meet together
No.
outside? So again, it has to be individual.
You have to declare a work session. You'd have to publish in the paper like this meeting,
Okay,
and you'd have to have an open room to, it would
okay,
have to be an open meeting.
gotcha.
And so without making a recommendation for this to go forward to council the way it is, how does that impact our goal of starting to review some of the rezoning permits if we don't have these?
So, rezonings are still subject to the moratorium. There's some other things, one, just being able to accept the applications, but also some of the policy documents. So any new rezonings can't apply right now as is.
So if we were to table this, if we were to make the recommendation to table it, 30 days is not necessarily going to make a significant impact on kind of our timelines for lifting the moratorium.
Correct.
Okay.
It will impact things that don't need rezonings at this time potentially. But as far as impacting rezonings.
Right. Because if these are intended for new developments, then that's all going to be things that are still part of it.
So this is going to, if it were to pass today or be recommended today and ultimately go to city council next Thursday, these standards as they stand right now would be in effect for new permits that are building permits from the ground up that have no rezoning or anything along those lines.
That's correct.
That's correct.
Okay.
And possibly some that are, not subject to rezoning, kind of already entitled.
Okay.
Some that may be under review or things of that nature, because this would go to two that don't have, that have not been permitted yet.
Okay. So to that point is that, let's say, if it were to pass and were to go to city council the next week and they passed it as it stood, how hard would it be to change those policies? I mean, we would be working with y'all, obviously, in the interim to that. And then we would just go through under new business, we would change the writing to the existing, what we have, to a more permanent, or not permanent, but a longer standing, a more
That's a
resident.
really good question. So the quickest it can go through the process, like if you make a recommendation tonight, it will go on Thursday for first read to city council.
Mhm.
And then, ordinances require 2 reads. So then it'll go, second read to city council on April 17th. And that's the soonest it can be adopted.
April 17th.
April 17th is the soonest can be adopted. If you postpone to a date certain today, then it will likely, because the advertisement is not complete for that, we'll have to talk about whether or not it will even go. We might request a postponement at the Thursday city council meeting and then not advertise for the April 17th. And then it would proceed for, recommendation from you. If for some reason it goes all the way through, gets adopted, but you'd like to kind of work with the text a little bit more, then it would be a new process. So it would be a new business agenda item because that one kind of moved on, got adopted. And we could take in all of your comments for changes that you'd like. present a new draft, and then you're right, we would kind of red line and strike the things that are different, because assuming that that would be adopted ordinance at that point. So now we're kind of redlining the ordinance that's already there, making those adjustments. And then it'd go through the same process through city council, 2 reads before city council to be code.
Okay, and that would end up being, if you change the wording around at that point, you're looking at May or June, somewhere along those lines.
Yeah.
That's
April, May,
correct.
June.
Is that right?
Yep.
So
June.
2 reads
Because
after
in
that.
June, we go down to 1 city council. You all already have 1 meeting per month.
Okay,
But in June, we go to 1 city council meeting instead of 2.
okay. As it stands right now. Okay. As it stands right now, there's no standards. From the ground up.
Minimal standards.
I think they're just guidelines.
Just guidelines.
There are no standards, only guidelines.
Yeah, okay, yeah, they are guidelines, so nothing that's like a mandate.
Okay.
And to be fair, that's kind of the fear from staff standpoint, right? It's gonna be, I can speak to that, right? The idea is that, someone would come in, we wouldn't have really anything to kind of tie them to for minimum standards that would match what we want to.
Right.
Trying to get something, I wouldn't say done and in, right? But we do want to make sure that we take into account any recommendations that both recommending and, approval bodies have.
Mhm.
And be mindful of that. But there is some kind of urgency to this.
Okay,
But I
understood,
do say that.
understood. What do you think? Anybody?
I mean, I certainly get wanting to have some sort of standards.
Mhm.
But I do like the thought of it being tabled so we can look at it, but if we can put it on the agenda for our next meeting or something to where we could potentially propose our changes then, yeah, I could be talking, I mean, I could vote yes. But again,
Mhm.
I mean,
I won't,
for me, I will defer to Chris's knowledge and
Yeah, I mean, Chris
and even
is-
Matt's around things like the
Mhm.
roof slope, because that doesn't mean a whole lot to
Yeah.
me, but there's a couple of things that I have questions on before I'd want to recommend it. So even
Yeah.
the windows piece, to me, that seems very, very specific. And I guess wanting to understand exactly what that means. And is there something in between what's here and something that's still quality, still meets the standards that we're going for, but is maybe something that would fit more into the realm of what most people want, especially if I think forward around, well, this is new build, but what about when we start establishing these for changes to existing, wanting to be able to set a consistent standard for people? And I don't know that that's a standard that I think is realistic to set for existing construction, that may have to be permitted for things as well, because then we might be setting expectations that don't tie into what they currently have. And we've got a lot of established residential construction.
Sure. And by urgency, I do want to make sure I clarify, 30 days is not outside the window, right?
Sure.
I
Sure.
just to kind of tell you from, they're the consulting side, staff side, right? I just want to make sure that we plan what the citizens want as, and get something in as urgently as possible. And that includes how you all want to set the standard. So when I say the sense of urgency, that's just me, driving the train, okay? But
Right.
30 days is not going to derail anything, okay?
Right. Be fast, but don't hurry.
Yes, that's it.
Awesome.
table.
Yeah, I think if we table it for 30 days,
Yeah.
review it, 30 days is not
It
gonna
gives us
make a
time
break.
to look at it.
The city was established, January 1st, we're 3 months in.
Yo, we are moving fast.
And everything's moving fast.
Yeah.
But it's still a brand new city and, I don't
Well,
think anything should be rushed.
I need a formal motion to table.
So
Go ahead.
to postpone to the April 22nd, regularly scheduled planning commission meeting.
Can I make a motion?
Yeah.
Okay, I make a motion to table this. TA 25-01, review of text, the UDO related to the architectural standards to single family multifamily residential uses, table it to the April meeting,
April 22nd.
April 22nd. Can I get a second?
A second.
All right, all those in favor of tabling, say aye.
Aye.
Any opposed? Okay, with that it passes 4-0. Getting close. Okay. The motion carries 4-0. I now will entertain a motion to adjourn the meeting. Is there no future business or current business?
I'll make a motion to adjourn.
Can I get a second?
Second.
All those in favor of adjourning, please say aye.
Aye.
Any opposed? No. Motion passes 4-0. Thanks so much, everyone.